Come back. If you are just joining us, you are on to your favorite program, Democracy on the Rule of Law. We're looking at the issue concerning the removal of the Code of Conduct Tribunal chairman. And of course, we'll be looking at the issue concerning the appeal court nullification of the judgment by the Federal High Court, delivered, of course, presided over by Justice Lifu on the Rivers State local government election. Of course, we all witnessed the controversy of that judgment, where the Federal High Court, has ruled that the security agencies should not avail their presence in the conduct of the Rivers State local government election, and also barring the Independent Electoral Commission (INEC) from releasing the voters' register to the Rivers State Independent Electoral Commission for the conduct of the local government election. Of course, that raised a lot of eyebrows at that time, where a lot of constitutional experts had one or two things to say concerning it. And in fact, even the Rivers State governor did allege that that was a fraudulent judgment on air, and that they were proceeding with the election. And of course, they proceeded with the election. But now, of course, we see the appeal court, modifying all of that. So what do you have to say?
Well, it's a good development that the Court of Appeal sitting in Abuja, the three-man panel presided by Justice Onyeka Jodisi, has nullified the judgment of Honorable Justice Peter Lifu in connection with the October 5 local government polls in Rivers State. When that judgment was given, we had the opportunity to look at it. And like what we said at that time, we looked at it as, does the Federal High Court sitting in Abuja possess requisite jurisdiction, the powers to determine the subject matter of the case? And what is the subject matter? The local government polls in Rivers State, the local government election in Rivers State. And when the judge came up with his, judgment and others, to the effect that the local government polls must not go on, and that Rivers State Independent Electoral Commission must not release the register for purposes of that election. And even went as far as restraining the law enforcement agencies, particularly the Nigerian police and other agencies, not to provide security during that election. And then we also saw another judgment from the Rivers State High Court, which gave go ahead for that election to be conducted. And of course, the election was conducted, and the Rivers State government went on appeal against the judgment of Justice Lifu, which case was filed by the APC. And good enough, the Court of Appeal had come up to say that that judgment lacked merit and has nullified it. And what were the grounds? The same grounds we mentioned earlier, which is lack of jurisdiction. We recall that Justice Lifu, when given his judgment, predicated same on the provisions of Section 28 of the Electoral Act. And on that basis, he assumed he had jurisdiction. But Section 28 of the Electoral Act had to do with federal elections. Elections that had to do with federal offices, not state offices. And because the said section deals with election into federal offices, and the conduct of the election in issue had to do with that of local governments, the Federal High Court had no jurisdiction. And again, the Court of Appeal had also gone ahead to, lambast the court for giving an order, which some of us view as being a curious order, that law enforcement agencies should stay away from the conduct of such election. We know that the Constitution has made provision for the powers of the Nigerian police. The 1999 Constitutional Amendments, as well as the Police Act, have made clear provisions that the police are there for protection of lives and property.
Which is one of the fundamental responsibility of government.
Yes.
Protection of lives and property.
Protection of lives and properties. So where a court of law is now giving an order that tends to, remove the constitutional powers given to an agency like the police, it's curious. But thank God the court of law has come forward to say yes, that judgment cannot stand. And such order can equally not be allowed to stand. Of course, let us look at it this way. Assuming that there were chaos, there were crises, there were life-threatening situations that day, and the police, in compliance with the order of the court, stayed away from the conduct of the election, what do you think would have happened? It would have been a free day for people with criminal intentions and tendencies to have their way.
Yeah.
But when we watched the election, the report thereof, it was peaceful, and the issues of ballot box snatchings and all those things were not there.
Yeah, it was peaceful, of course, but we saw the burden of some local government after the election, after the police had withdrawn their presence in some of those local governments. So the question is that should we be thanking God for this appeal court judgment, or should we be making more inquiry why, a federal high court, of course, a court of superior, jurisdiction should not understand the difference, between or have a proper grasp of its jurisdiction, because of course the appeal courts have said that they do not have jurisdiction to even interfere in that matter, and that local government should be for state. Of course, they shouldn't we be beaming our searchlight, why the federal high court, of course, failed to take cognizance of this basic issue of jurisdiction. One, the issue of constitution, given the fact that the constitutional provision for the security agencies and the principal and the primary responsibility of government is to protect life and property, by giving what you have described as a curious judgment, by restricting the security agents from performing their constitutional function. Should we just be thanking God for this appeal court intervention, or should we be querying more or asking more questions why that judgment should have even been given in the first place? Because of course it could repeat itself and there could be chaos in future.
Yeah, well, the issue of asking more questions or prying or investigating, those ones do not lie on our table. That is beyond what we can do here. But
as Nigerians, of course, we pay their fee. They sit there on our behalf. They represent the interest of Nigerians, yes. And of course, they sit there on taxpayers' money. So yes. Of course, the people have the responsibility, to inquire of how they discharge their functions, given the fact that they pay them.
Well, I know that if there's any query, any inquiry, or anything that needs to be done further after the court of appeal,
or is it okay for
only the NJC that can do that?
Shouldn't the people be demanding that the NJC do that, or should
the NJC doesn't just, if a judgment is upturned, go ahead?
Not just upturned. Of course, you have described it as a very curious judgment, because it was a judgment that raised a lot of. It was not a judgment that dealt on the borderline of constitutional confusion, where it could either swing both sides. It was a clear provision of the Constitution that the judge decided to look the other way and give a curious judgment, as you have described.
I did not say he decided to look the other way.
Well,
what I said is that the judgments were curious to the extent that the judge said that law enforcement agents will even stay away, which means if they were hoodlums, if they were people with dangerous weapons, they can have a field day. And that order is against the clear provisions of the Constitution.
Yeah, that is why we
and the Police Act. Now, the Federal High Court is a court of enumerated jurisdiction. It is not a court with unlimited jurisdiction. It used to be the Federal Revenue Court when it was established in 1973. Later, it became the Federal High Court and had other jurisdictions given to it, as contained in Section 251 of the 1999 Constitution. Now, the clear thing is that a judge before whom a matter is brought has the powers to look at it, whether he has jurisdiction. And that is why it has been said time and again that jurisdiction is the lifeblood of any matter, any litigation. It is fundamental that it can be raised at any stage of the proceedings. And of course, we know that when issue of jurisdiction is raised, the judge ought to determine it first and foremost before proceed, so that it will not be a waste of precious judicial time to go ahead and conduct proceedings, conduct trials and everything, and at the end of the day, it is discovered that the court lacks jurisdiction. Because whatever the court may have done, no matter how beautifully done, will amount to a nullity, so long as there is no jurisdiction. And of course, in any contest in court, there are two parties before the court, or multiple parties, and then the judge. Maybe they raise the issue of jurisdiction, and then the judge ruled against it. Whatever may have happened, the court of appeal has said the court lacks jurisdiction to entertain the matter in the first place, because it does not have to do with federal offices. The election has to do with local government.
Wasn't that, yeah, the question was that, wasn't that elementary in the first place? Because the Nigerian people deserve, are you saying that the Nigerian people should have no expectation of the people who, preside over the justice system, of things that is ordinarily expected to be elementary? Or should we just, whatever they can decide whatever they like, irrespective of what, because from what this, we have said, this could have caused chaos, could have led to loss of life. And should we just be thanking God that it did? Because of course we still have elections coming up. We still have federal elections coming up in 2027. And of course, when we have curious judgments, as you have described, coming out from courts of superior jurisdiction like this, shouldn't the Nigerian people be demanding more?
Now,
because all people who are not judges, of course, said that this.
I want to say clearly that in recent times we've been having judgments, particularly judgments and orders that are conflicting in respect to the same subject matter. Recall Kano State episodes, the Emeship tussle, and they were conflicting judgments and orders, conflicting orders from courts, from federal high court and state high court. And then it is high time, our judges need to be very clear as to the subject matter over which they have jurisdiction. Because we saw conflicting orders, one from the federal high court, another one from the high court in Kano State.
Not just Kano, in several instances, even in Rivers State, in many states.
Places, there are so many conflicting judgments coming from courts of coordinated jurisdiction over the same matter. And do you know what this tends to portray? The average Nigerian believes that some of these things were done intentionally, maybe because of some other things, some other considerations other than law. But as lawyers, we know that a judge may be mistaken as to the law or to the fact, but what is imperative is that henceforth, going forward, let our judges always be more serious as to matters they entertain, especially matters that has to do with elections and politics. But these things are more rampant in election-related matters, political matters, and so on. And it gives a very bad impression to the average Nigerian about our judiciary. Because where there are two conflicting judgments or orders in respect of the same subject matter on the same parties, the question has always been, which one will the parties comply with? And then you say it is not a good omen for our judiciary, and it is high time. And I'm aware that the NJC has had cause to summon the chief judge of a particular state, particular Rivers State to be precise, over completing orders and judgments emanating from that state. And Rivers State has been a hot spot for for very many completing orders and judgment and decisions by cause of coordinated jurisdiction in Rivers State. And that is worrisome.
Well, some people will say probably a closer or a more robust inquiry might lead to maybe better training of the judges. Appointment process might be reviewed. Of course, that is what is done in companies. That is what is done in an establishment. When you look at the recruitment process, whether there are some things that needs to be changed, you look at training of staffs. If mistakes like this continues, to occur. Of course, so probably this is an opportunity to look at more reform in the judiciary.
Yes, well, of course. course, I'm aware that President of the federal government is undertaking, a kind of reform of the, administrative justice system in the country, and then also beaming a light on the mode of recruitment of judicial officers. That wouldn't be like a question of who knows who. There are very good, very sound, brilliant lawyers there who may never smell the bench. Not because they are not qualified, but because they are not in the good books of those who are, decision makers as far as appointment is concerned. Because we can say that these days, some people who are sons and daughters of serving or retired judges or justices, and the sons and daughters of politicians are the ones that we see usually sometimes appointed as judges.
Yeah, that brings us to the question whether is it proper for the spouses, relations of politically exposed people, to man our judiciary? Should there be a law restricting politically exposed people, close relative of politically exposed people, such as their wife, their children, governors, president, House of Rep members, from holding judicial offices, given the sensitivity of that?
No, that would be discriminatory. Of course, the Constitution is against discrimination in any guise. So if you come up with a law discriminating against the spouses or relations of politically exposed persons, as you put it, from being appointed judges, that will be discriminatory. But what is important is that let there be a fair playing field, and let recruitment be based on merit, on competency. If the daughter or the son or the spouse of a judge or political appointee or whoever is qualified without other considerations, let him have be appointed. But if that person gets an edge because of his or her relationship, either by being the son or daughter of a judge or a political office holder, and this other person who is more qualified is denied that opportunity because it's not the son or the daughter or relation of either a judge or a political office holder, then there is injustice and it needs to be addressed. And that means that we need to look at the recruitment process, and of course the issue of training and retraining of judges. I'm aware of the continuing legal education for judicial officers. They always meet and share ideas, and it is necessary for occasional. Of course, the judges always go on a retreat and get retrained and retrained and retrained. These things are very important because society is dynamic, and we cannot afford to allow our system to be static. So it is clear that it's necessary for the modes of appointment, the criteria, and all those things to be reviewed so that we can have a better justice administration system that is, in tandem with international standards and best practices.
Well, of course, some people Nigeria would say that the law should always respond to be dynamic and unique to where it operates. Of course, we saw the bureaucratization of the justice system, where one of the judges says that, of course, his wife have extended help to his political colleague. We said it in the floor of the Senate. One of the wife of this thing. Now we have seen several instances. So there has to be balance, between these politically exposed people. If people can say their wife had extended help, to their colleague, they have prevailed on their wife, who was one of the judges. So, of course, there has to be balance with these things. Of course, we are a little bit out of time. We'll take your last word for call it a day on today's episode.
Yes, on the issue of the Daniel Omaro issue, it's good for the Senate to go back and do the right thing to avoid further embarrassment on the nation. And then concerning the Court of Appeal decision, nullifying the judgment of Honorable Justice Leto of the Federal High Court in Abuja is a good development.
All right. Thank you for gracing the show this evening. It was nice interacting with you, and it was very, very insightful, hearing from you. So this is where we'll draw the curtain on today's episode on democracy and the rule of law. Of course, meet us same time next week as we look at more trending topic, and also do well to follow us on all our social media channels.